I'd like to welcome everyone tonight to the University of Tulsa College of Law. I am Janet Levitt. I'm the Dean of the College of Law, and it's just a pleasure to see so many students and faculty and members of the community here today. This lectureship in law and politics really embodies two fundamental principles which are at the core of this school and I think are at the core of the study of law. The first is the importance, the critical importance of interdisciplinary dialogue and discourse in illuminating important issues of both law and politics. And I'm very thankful to my colleagues in the political science department for instigating, propagating this lecture. It's a very important part of what we do here. And the second fundamental principle that this lecture highlights is that the study of law and the practice of law necessarily touches upon issues that are difficult, that can be controversial, but lawyers we pride ourselves on maintaining civility and a steadiness of the hand in debating these types of issues, and I know that that tradition is going to continue here tonight. So with no further ado, I'm actually going to introduce now Michael Mosher, Professor Michael Mosher, who is the chair of the Political Science Department here at the University of Tulsa, who is going to introduce our distinguished speaker.
Actually, there's going to be a long series of introductions. I'm going to introduce somebody else before we get to the speaker. It is a pleasure and an honor to be able to introduce Ian Shapiro, the Sterling Professor of Political Science at Yale. He's quite evidently a perfect fit for a lecture series that tries to connect the dots between the activities of lawyers and the activities of political scientists. For Ian has both a JD from the Yale Law School and a PhD in political science also from Yale. He's currently a teacher in both the political science department and in the law school. Professor Shapiro's educational credentials remind me of the fact that many, many years ago, political science was a subject exclusively taught within law schools and law faculties. Now, Ian Shapiro and I have known each other now for about 15 plus years, during which time I stood both near and farther away in a state of more or less steady amazement at his prodigious energy, the diversity of his intellectual interests, and his accomplishments. In trying to characterize Ian for you, I can think of no better way to do so than to speak of the company he keeps. For two, maybe three generations, the subject of political and legal philosophy, once thought to be moribund, has flourished both on this continent and in every place where societies have carved out time and space for this kind of serious self-reflection. Ian Shapiro himself calls it principled social criticism. In this regard, Ian keeps the company of and with, at one point or another, has actively engaged with all the very best minds in this ongoing conversation, beginning with analytical philosophers like John Rawls and Robert Nozick, with jurisprudential figures like Ronald Dworkin and Bruce Ackerman in prominent law faculties, with the historians of political thought such as Clinton Skinner, Leo Strauss, and John Pocock. The story continues with figures like Michael Walzer, Judith Shklar, and Charles Taylor. These names may or may not be familiar to you, but I can assure you they are the most distinguished figures of two generations. In fact, I would submit to you that with the retirement of Michael Walzer, who was a guest here in this series in 2004, Professor Shapiro is probably the best democratic theorist we have in our midst. So I'm just going to take a little time to trace out Ian's intellectual trajectory. His first book, Evolution of Rights, was a philosophical reconstruction of the history of rights in four distinct stages. It marked out a distinctive style and perspective. While evidently a friend to the tradition of rights, he raised tough-minded and skeptical questions about that tradition which too many authors before him had ignored or elided. The book made an impact. His follow-up work, Political Criticism, was a similarly tough-minded and illuminating set of appraisals of more or less the entire legion of contemporary historians of political ideas and of political and legal philosophers. From there, his critical mind veered off in an unexpected direction to take on the newest and, by some estimates, the reigning methodological fashion in the social sciences, namely rational choice. In both the resulting book, The Pathology of Rational Choice, and an allied publication, a recent work called Flight from Reality, he lamented the ever ongoing tendency in the social sciences to operate with a vocabulary and a theoretical perspective so distant from the actual problems of the world as to be of little use either to policymakers or to yourselves, the informed public. When Ian was chair of the political science department at Yale, he worked hard to focus colleagues' and students' attentions on actual policy problems, going to the extent of supplementing the ancient fourfold division of the field into the ancient fourfold division is political theory, American politics, comparative politics, and international relations. He supplemented that with a set of divisions that instead focused upon actual problems of order, violence, distribution, political conflict. Now, having, so to speak, as a younger scholar, cleared the decks with what, in his view, was wrong or missing in the intellectual heritage of political and legal thought, Ian turned his talents to the positive program, namely what he believed to be the case about the circumstances of and the prospects for democracy. In the course of doing so, this native South African became one of America's most eminent democratic theorists, as evidenced in volumes like Democracy's Place, Democratic Justice, and The Moral Foundations of Politics, a book that I myself use. As an offshoot of this work, and with colleagues at the Yale Law School, Professor Shapiro focused increasingly upon the problems of inheritance, why, for instance, the inheritance tax was abolished, and on the general problem of distribution and democracy, to invoke the title of a volume now under contract. I mentioned that Ian hails from South Africa. Coming to the United States by way of Britain, he's now a U.S. citizen, but he has always paid scholarly and attention in numerous articles to South Africa's transition to democracy, and as well to the overall subject of so much importance to our generation of the democratic transitions going on throughout the world. Post 9/11 developments found Ian diving into a new arena, international politics. The subject of his noon lecture today, and as well the subject of a recent book, Containment and the Global Strategy Against Terrorism, his arrival as a specialist in international relations was made further evident by his assuming the directorship of the Yale Macmillan Center for International and Area Studies, and his being elected in 2009 a member of the Council on Foreign Relations, which is a nice follow-up to his earlier election to the American Academy of Arts and Sciences. Well, hopefully I've said enough for the audience to appreciate this scholar's diversity of interests. And indeed, immersed as the audience possibly now is in imaginatively considering the global topics that dominate the Council on Foreign Relations, we are rather far from the topic of tonight's lecture, the constitutional politics of abortion in the United States. But I hope in this summary of Ian Shapiro's career I have instilled confidence in the audience that he will be able to deftly reel us back into the subject at hand. So I give you Ian Shapiro.
Well, thank you very much for inviting me here, and thank you all for coming. I am speaking tonight about the constitutional politics of abortion for two distinct but related reasons. One is, I think, the inherent importance of the subject of abortion and the moral problems and challenges that it generates, but also because, as is captured by the title, The Constitutional Politics of Abortion in the United States, I think that if we understand the history and evolution of this controversy in the U.S. since the 1960s, it really gives us a window into thinking about what the role of a constitutional court is in managing deeply divisive issues in a democratic culture in which people nonetheless are committed to trying to live together and finding a way to, if not resolve their disagreements, manage their disagreements. So what my ambition is to both illuminate the ways in which the courts have grappled with the subject of abortion in conversation with the legislatures, both the state legislature and now also the congressional legislative branches over the years, but also then in turn use that to think about what is the place of the court in a constitutional democracy, particularly as it relates to extremely divisive issues where you have intensely felt commitments and beliefs, but deep divisions over those beliefs. And so my plan is to walk us through the history, fairly briefly, the history of the constitutional politics of abortion in the U.S., but then to go back and look in more detail at what has been at issue in that history over time, how it has evolved, and what it tells us about the future of the constitutional politics of abortion in the U.S. and the place of the Constitutional Court in the American democratic political order. So that's the agenda, and what I'm going to do is I'm going to start at the end with the 2007 decision by the Supreme Court, Gonzalez versus Carhart, and then we're going to go back to the beginning, and then we'll work our way forward to where we are now as a prelude to looking more analytically what has been at stake in these debates. So in 2007, the Supreme Court handed down a decision, Gonzalez versus Carhart, in which it upheld the congressional ban on so-called Partial Birth Abortion Act that President Bush had signed in 2003 and had actually been struck down by the lower courts following a decision from 7 years previously called Stenberg versus Carhart, a Nebraska case in which the court had upheld a very similar partial birth abortion ban statute that had been enacted by the state of Nebraska. Of course, one difference you can see by looking at those two decisions is they're both 5-4 decisions, but in the Gonzalez case, we have the two new appointments to the court, Chief Justice Roberts and Justice Alito, whereas in the previous case, we still had on the court Sandra Day O'Connor and and Justice Rehnquist, who had since gone. Justice Rehnquist didn't change sides, but of course, the replacement of O'Connor by Samuel Alito produces the switch in that decision. And I'll come back at the end to talk about what the change between the 2000 Nebraska case and the 2007 federal case implies. But that's sort of where we are today. And what I'm going to do here is to focus my discussion around three different topics, which I'm calling three windows into the constitutional politics of the Supreme Court. We're going to focus, first of all, just on what was decided, the substance of abortion law as regulated by the court going back to the 1970s. Actually, it starts in the 1960s, as many people here know. Then we're going to turn to the process by which the court operates in this area, focusing on how questions are decided. And then third, we're going to turn to why it was decided, the different rationales that have been given by the court at different times for what it's done in the abortion area. So first of all, what was decided? And here we're going to focus our attention on that's sometimes called the three-trimester test that we'll find in Roe versus Wade versus a different standard for evaluating statutes governing abortion that was announced in 1992 called Undue Burden. And I'm going to spend a considerable amount of time on the differences between those two things. But the story all starts, at least the modern story starts in 1965 with a case that had nothing to do with abortion, namely Griswold versus Connecticut, This was actually a case about contraception, in which there was a long disused statute on the Connecticut books outlawing physicians from giving from giving married couples advice about contraception. And this was challenged in the courts, and the challenge was upheld in this opinion, Griswold versus Connecticut. And the reason this turns out to have been important for subsequent history of abortion jurisprudence is this was the case in which the court set its sights on a notion of privacy. That is, in Griswold versus Connecticut, they talked about the privacy of the marital bedroom as being something that could not be invaded by the state of Connecticut. And so this notion of privacy, at least in this case, it was the privacy of the marital relationship that was held to be sacrosanct and upheld against the rights of the state of Connecticut in that matter. A few years later, in a case called Eisenstadt versus Baird, the question was put, well, if it's privacy, just whose privacy is it? Is it the privacy, as Griswold had been about the privacy of the relationship between the husband and wife? In Eisenstadt versus Baird, they said, no, it is actually the privacy that attaches to individuals that is protected by the Constitution. And this would be the setup for much subsequent controversy, because although these cases were not thought to be particularly controversial at the time, there is no occurrence of the word privacy in the Constitution. And so the question was, where does this term privacy come from? Where does this constitutional right to privacy come from? And people who are concerned with the technical constitutional law issues have argued for decades about whether and where and how the right to privacy is or is not entailed by different parts of the 5th, 14th, and other amendments. But the fact that it's not mentioned in the Constitution was going to be a source of great controversy later. And of course, the year after Eisenstadt, we get the famous decision in Roe versus Wade, where Justice Blackmun wrote the majority opinion defending the constitutional right to abortion. And just to be clear on what Roe actually held, people very seldom actually read this opinion, but Justice Blackmun basically made up a 3-part rule. He said, for the stage prior to pretty much the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. Second, for the stage subsequent to the end of the first trimester, the state, in promoting the interest in the health of the mother, may, if it chooses, regulate abortion procedures in ways that are reasonably related to maternal health. They can regulate abortion, but only to protect the health of the mother. Then third, for the state subsequent to viability, which in those days was roughly coextensive with the beginning of the 3rd trimester, the state, in promoting its interest in the potentiality of human life, and this of course is the key notion here, that the state of Texas was held to have an interest in protecting potential human life, may, if it chooses, regulate and even proscribe abortion, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. So Roe versus Wade actually recognized that the state of, in this case, Texas, did indeed have a legitimate interest in the potentiality of human life, which it could, if it chooses, regulate and even prohibit abortion. But then it created this escape clause, except where it's necessary in appropriate medical judgment for the preservation of the life or the health of the mother. And because appropriate medical judgment was here taken to be the judgment of the attending physician, and because the health of the mother was taken to include psychological health, for all practical purposes, Roe versus Wade created a right to abortion on demand. However, it's important to note that even though Roe did not really make it practically possible for states to prevent abortion, the court had recognized this state legitimate interest in potential human life, which would turn out to be important later. And the law of abortion was governed by Roe from 1973 until a decision much later, 1989, Webster versus Reproductive Health Services. By then, the personnel on the court had evolved considerably. Rehnquist was now Chief Justice, and we can see a very significantly different makeup on the court. This was a remarkable decision for a number of reasons, this 1989 decision, and I'll just talk about a couple of them. One of the things that signals what a remarkable decision it was is that both Justice Scalia and Justice Blackmun were furious with the majority decision in this case. Why were they both furious? They were furious because both of them were convinced that the Webster decision had destroyed Roe versus Wade, but without admitting it. And so the source of Scalia's fury was, he said, why don't we just come out and say we've basically reversed ourselves with respect to Roe, instead of pussyfooting around and pretending that we haven't. And Blackmun said pretty much the same thing from the opposite ideological point of view. He said, the most important decision of my lifetime has been destroyed by this opinion, and the majority are not even admitting that they are doing it. Why were they both so angry? The reason they were both so angry was that the Webster decision recognized that this state's interest in potential human life exists in principle even before the point of viability. The state's interest in vindicating or protecting potential life was seen to be valid before the point of viability. And both Scalia and Blackmun correctly inferred from that this meant the end of Roe's trimester framework. Because if you're recognizing a right of the state to protect potential life before the point of viability, you have de facto, you've thrown this trimester framework out of the window. So Scalia was saying, why don't we just face up to the fact that we've done this and that the whole story is over? And Blackmun was saying, you're pretending not to have destroyed the most important decision of my career, and the most important decision, in his view, that the court had made during his career, without admitting it. And the net effect of that, I'm sure many people in this room will remember, was massively to ignite popular action about abortion on both sides of the question, because it was very unclear where this was going to be going after that. And if you recall, in the primaries in the run-up to the 1992 presidential election, this was a huge issue. In the Democratic primaries in particular, Bill Clinton and several other candidates ran on the proposition that if elected, they would ensure that Congress passed a statute to essentially recreate Roe, put it back into place, feeling that in response to the supposition that it had actually been destroyed by Webster, and it was now just a matter of time before the effects of that would filter their way through. So the 1992 primary, well, it was really the 1991 and then early 1992 primaries abortion was a very charged issue during that election. But the wind went out of the sails, particularly on the Democratic side in the summer of 1992, when the court handed down another decision, Planned Parenthood versus Casey, a Pennsylvania decision, in which the majority from Webster clarified what exactly they believed that they had done. And this, of course, turns out to be the major decision on abortion since Roe versus Wade, where the court staked out its new jurisprudence of abortion decision-making that would govern everything that happened into the future. The architect of this was Sandra Day O'Connor, an appointee of Ronald Reagan, as you can see up there. And they articulated this notion of undue burden. And the notion here was a very different one than which had been deployed during Roe versus Wade. That what they tried to do was to treat the conflicting claims about abortion in a way that is comparable to other areas of constitutional law where competing valid claims run into one another. So if you said, well, what does this idea of undue burden mean? Basically, they said courts can regulate abortion from the perspective of protecting potential life, but not in ways that place undue burdens on the woman. Well, that obviously raises the question, what makes a burden undue? Here I have one paragraph where they talk a little bit about it, but it doesn't tell you a whole lot. Finding an undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking abortion for a non-viable fetus. That just raises the question, well, what is a substantial obstacle? How do we know a substantial obstacle when we see one? So why do I say that what they were really trying to do was analogize this to other areas of constitutional law where you have conflicting valid claims? What I'm trying to get at here is what they were trying to say is not that one side is right and the other side is wrong, but that when a constitution affirms multiple values, sometimes those values can't be mutually satisfied, can't be satisfied at the same time. So, for example, we have a constitutional protection of the right of freedom of association. Well, freedom of association, it was often argued, should allow people to associate with whomever they choose, and if people wanted to form clubs that excluded African Americans or clubs that excluded Jews, surely that should be their choice. What does freedom of association mean if you can't freely associate with whomever you choose to? On the other hand, there's the Equal Protection Clause, which requires equal protection of the laws, and people would go and argue that oftentimes power elites within these clubs would be making decisions that essentially affected the way in which power was exercised in the society, and so by excluding people from these clubs, there was an affront to equal protection of the law. Now, this is not to say that freedom of association is wrong and equal protection of the law is right. Rather, what it is to say is that these are both important constitutional values, but sometimes they clash. And when they clash, you have to figure out what it is that you're going to do. So this is what was motivating Sandra Day O'Connor and the majority in the Casey decision, was to move away from this question, this approach of saying who's right and who's wrong, and rather into the direction of saying how do we create a constitutional scheme for managing the conflict between a woman's right over the sanctity of her body and her reproductive choices on the one hand, and the state of Pennsylvania's right, in this case, to protect potential life on the other. They are both valid claims, and therefore we have to think about some system of balancing them against one another. And so they came up with this idea of undue burden. They said states can regulate abortion but not place undue burdens on women. Now, I will say a little bit more shortly about this idea of undue burden, but I just wanted to make a couple of points about it before moving on, because we're going to get to the end of the history and then we're going to go back and dig in a little deeper. Just a couple of things to notice about it, though, before we loop back and look at it more closely. One is that Justice Scalia, who was deeply unimpressed by this move, said one of the many terrible things about this is that it's going to promote endless litigation because nobody knows what undue burden is. And I just want to mention that and flag it, and we'll come back to it and ask the question, how good or bad is it that it would promote litigation? But the main point is to see that they have moved into this area of balancing valid claims rather than trying to say which one is actually right. That was 1992. Now we're getting back toward where we started. The court was silent on the abortion question for 8 years after Casey until this 2000 case, which took up the Nebraska partial birth abortion statute that I mentioned to you. And there was the first time they actually began to grapple with, well, what does this idea of undue burden actually mean? And the case there was this much disputed and debated and controversial abortion procedure, so-called partial birth abortion, that I should say that there's some confusion in the public discussion of this. Partial birth abortion tends to get conflated with late-term partial birth abortion. They're two different things. Most partial birth abortions are, in fact, second trimester abortions. But it's a procedure in which the fetus is partially delivered during the process of the abortion because it presents feet first. And the argument for doing it was that when the fetus presents feet first, it is safer for the woman in certain circumstances to have this procedure than not. That's a factual claim which some dispute, and I'll come back to the factual disputes about it because that's really what becomes important in the congressional statute 7 years later. But that was the claim, that in certain circumstances it is medically safer for the woman to have this procedure than any other procedure. So what the court did in grappling with this, I think this is the clearest reconstruction I can give of the thinking that was involved. The court said to itself, or the majority on the court said to themselves, well, whatever else undue burden might mean, surely it must include the idea that in a situation where an abortion is legitimate, if a more safe procedure is available, it imposes an undue burden on a woman to insist that she undergo a less safe procedure. Whatever else undue burden must mean, surely it means that. And so we get 5 justices signing on to that idea. Now, just in terms of keeping track of the justices, notice that in Planned Parenthood versus Casey, we had 5 justices on board with the idea of undue burden, right? Blackmun, Stevens, O'Connor, Kennedy, and Souter, whereas Rehnquist, White, Scalia, and Thomas were in the minority. So it was a 5-4 decision. Now, between then and 2000, the balance on the court actually changes because Justice White retires and is replaced by Stephen Breyer. So one would have thought there would now be a 6-3 decision because Kennedy in 1992 had signed on to the idea of undue burden. So, but yet we still have a 5-4 decision because Breyer comes in onto the court and signs on to the majority opinion, but Kennedy moves, and Kennedy is therefore very interesting justice on this subject because he seems on the one hand to have committed himself explicitly to this undue burden standard enunciated in the Casey decision, but in the one and only application of it that the court has tried, he went to the other side, and he simply didn't buy this reasoning that whatever else it means, if a more safe procedure is available, a less safe procedure can't be insisted upon. And Kennedy is actually something of a mystery. I will come back to that. But in any event, because Breyer had replaced Whizzer White by this time, it meant that there was still a 5-4 majority in that decision. But then, as my very first slide this evening showed, by the time 2007 rolls around, the tables are turned because now we have Chief Justice Roberts and Samuel Alito having replaced Sandra Day O'Connor and Chief Justice Rehnquist. So that is the quick run through the history. But now I want to focus on more analytically what has been going on here and the question how the course operates. And I want first to talk a little bit about the process that the court went through. One of the interesting things, I think, about what of the misjudgments made by Justice Blackmun in Roe versus Wade was he really thought when he wrote that opinion that he had solved the question for all time, that he had taken it off the table by writing a very detailed statute, his 3-trimester test, and calling it a Supreme Court opinion. At the time, as today, the American public was deeply divided about this question. Some states had legalized abortion through legislatures. Some states recognized a right to abortion in their state constitutions. Others had made it illegal either through legislation or through interpretations of their own state constitutions. It was in an area of considerable ferment. And when the court entered the fray, it behaved in a very imperialistic fashion, not only for the reason that I've already mentioned that and is often talked about in the literature, that it grounded this right to abortion on the concept of privacy, which appears nowhere in the Constitution, and made it seem like a somewhat illegitimate decision for that reason. But also it was a very imperialistic act by the court. As I said, he wrote this very ambitious and aggressive statute that he thought would solve the question for all time, but in fact really poured gasoline onto the controversy in the society. Compare that with what the court did in Brown versus Board of Education in 1954, when Earl Warren was Chief Justice. The issue was no less divisive, especially in the South, and the court was going to enter the fray of segregated schools, an enormously controversial and difficult issue for this democracy. One thing Warren realized was that he had better put together a unanimous court. which he succeeded in doing. There's actually a fabulous book called Simple Justice about what went on in the internal politics of the court for him to get unanimity for the Brown decision. But one of the most interesting features of that decision was that the court said in Brown 1, the first decision, the 54 decision, separate but equal will not stand. And they didn't say anything else. They didn't say what would stand. They said this is unacceptable. They said separate is inherently unequal, and it violates, therefore, the very idea of equal protection built into the American Constitution. But they didn't say anything else. And so they essentially threw the matter back to the southern state legislatures, implicitly saying, come up with some other way of arranging education and we'll see. So they acted, if you like, in a democracy-enhancing way, even when they intervened in the democratic process. They didn't arrogate power to themselves to reorganize the schools. And so they threw it back to the legislatures, and then we had a multiple decades-long period in which first the state legislatures and eventually the federal Congress became involved in efforts to desegregate schools. It was, of course, contentious because it was a very divisive moral issue, but the courts played a kind of reactive role in all of this process. There's an excellent book called The Hollow Hope by a political scientist at the University of Chicago that details the fact that every major move in school desegregation that occurred in the South actually happened through legislatures and not through courts. Despite what we, in the public rhetoric, we hear about court-ordered busing and so on. This was not the engine through which desegregation was actually achieved. So the approach that was taken in Brown was a democracy-enhancing approach in that it saw one of these situations of deeply conflicting values, and it acted in a reactive way, throwing it back into the political process for further action by the legislature, rather than in the imperialistic way that Blackmun behaved in Roe versus Wade, where he arrogated the power to the Supreme Court to write a statute of its own, thinking this will take it off the table, when in fact it had the opposite effect of fueling political controversy about it. Okay, so let's now talk a little bit about why it was decided as it was. And here I think there are three basically competing ideas that have been in operation in arguments about abortion. Privacy we've already talked about. It's this notion that isn't in the Constitution and therefore made the jurisprudence that flowed out of the concept of privacy, first in the contraception cases and later in the abortion case, seem inherently suspect. Ruth Bader Ginsburg, before she was on the court, made a famous speech at NYU in which she said Roe versus Wade was a badly reasoned case, precisely because of that. And when President Clinton nominated her for the court, the Democrats, in fact, gave her a very difficult time during the confirmation hearings because of that, and they weren't sure what her view about abortion was. But basically her view was that all along it would have been better to make an equal protection argument, arguing that women should not have to bear any more than necessary regulations in the matter of abortion because it put them at a systematic disadvantage and an alternate rationale could have been developed along those lines, but it was never done. And so there was, in the run-up to Casey, there was a lot of speculation about whether there would be this alternative equality basis for the decision. As it turned out, in Casey, the court decided to punt on this question. They decided to invoke the doctrine of stare decisis. They decided to say many of the people who were on the majority side, they said, had we been on the court in 1973, it's far from clear that we would have come out in favor of this decision. And even if we had, it's far from clear what reasoning we would have given. But this is 2 decades later. This is now settled law. It is built into the fabric of people's expectations. So, and this famous first line from Sandra Day O'Connor, liberty finds no refuge in a jurisprudence of doubt. We're not going to reverse what was done 2 decades ago. We're going to recognize a constitutionally protected right to abortion, and we're not any longer going to visit the question of what the ultimate justification for it is. So, where does that leave us? I think there are several things to focus on. One is Justice Kennedy. It's very unclear what Justice Kennedy's view actually is. If you read the opinions that he has written, he is pulled very much in both directions. He has signed on to the idea of undue burden on the one hand. On the other hand, it would seem like in the debate about undue burden, it's a pretty strong argument to say, well, if we've determined an abortion is legitimate, then surely a woman should not be required to undergo a less safe procedure if a more safe procedure is available. That whole issue has now become much more complicated for the following reason. After the 2000 decision on the Nebraska case, Congress got involved. Congress got into the act and passed the 2003 act that President Bush signed. In the course of passing that act, they held hearings. Congress held hearings in which they took testimony on the question of whether or not it is medically safer in some circumstances or not. And they said, after those hearings, that it's not. That we, the Congress of the United States, find that it is never medically indicated as safer for the woman. So on the one hand, that looks like a pretty big difference. You know, if we think about this Brown logic, throw it back to the legislature picked it up, they deliberated, and that's what they said. The trouble is that if you look at the hearings they actually held, they were pretty somewhere between cursory and bogus in the sense that they didn't hear from anyone who had any experience with this procedure. They ignored all of the testimony from the American College of Obstetricians, and they said things like no major medical school teaches this procedure, when in fact almost all of the major medical schools taught the procedure at the time. So they were not impressive hearings. If you just sort of look at them from the point of view of a dispassionate regard for the truth of the matter, it seemed like they were designed simply to produce the desired result. Now you might say, well, maybe, but if that's the case, shouldn't the remedy be with the people who elected them rather than with the court? And I think that that is a very hard question. It's a very hard question, and we can come back and talk about it further if you want during the question time. It's a very hard question because, as Justice Thomas has said in another context, if a legislature said black is white, we wouldn't accept that courts wouldn't defer to any factual claim that a legislature made. And so how do we draw the line? When do we say congressional hearings are so bogus or so clearly driven to get a particular result that we're not going to take them seriously, versus saying, well, the remedy would be with the voters and not with the courts. But in any event, that is a difference between the Nebraska case and the federal case. And just while I'm on this point of Congress getting into the act there, I think it's important to make another point that nobody seems to have made in the literature, which I find quite surprising. Before 2003, the general stance of those on the court who were against Roe versus Wade, such as Chief Justice Rehnquist and Scalia and others, was, of course, never that the court should find that abortion is unacceptable. Rather, it was that the court should reverse Roe and return the matter to the states, right? That essentially, I mean, that is consistently was Rehnquist's view from 1973 forward. The courts have no business in this area. This is a matter of states' rights, should be returned to the states. And that certainly has been Scalia's view all along. Now things are actually different because Congress has entered the field. The 2003 Act is the first piece of federal legislation regulating abortion. And so I think one of the things that's going to happen is that there are going to be supremacy clause issues that enter into abortion jurisprudence and abortion litigation in the future. Neither party in this case, in the 2007 case, raised supremacy clause questions. I think they both had their strategic reasons for not doing it. But I think they are there lurking in the wings and are going to reassert themselves or assert themselves for the first time. So Kennedy is a mystery. I think that is the first thing to say. We don't really know whether he's had second thoughts about the undue burden itself, or it's just as applied in this instance that he was persuaded by the back and forth about these factual questions, or whether there's some other issue. It's very difficult to disentangle from his opinions. At least I haven't been able to do so. The second puzzle in the current state of the court has to do with Chief Justice Roberts and Justice Alito. If you read the 2007 opinions, you have the majority opinion, and then you have a concurrence written by Scalia taking his usual view that the court shouldn't be in this business at all, and we should just reverse the decision in Roe and get the court out of this business altogether. Well, in previous decisions, and Clarence Thomas signed it as well. In previous decisions, Justice Rehnquist's name would have been on that concurrence as well. But neither Roberts nor Alito signed that concurrence. How should we interpret that? Nobody knows, except perhaps them. Does it mean that they've bought the idea of undue burden and just agreed with Kennedy that it didn't apply in this case? Does it mean that they're actually ready to reverse Roe completely and repeal the constitutional protection for a woman's right to abortion, but for some reason chose not to use this as the occasion? Or does it mean something else, like they haven't yet decided? We simply don't know the answer to that question. And then finally, of course, Justice Ginsburg has pancreatic cancer, and who knows how long She will be on the court, and Justice Stevens, I believe, just turned 87 or 88, 87. And so who knows how long he will be on the court. So who manages to replace them will obviously be hugely consequential in this area. The thing I think I would say in conclusion, though, is that I mentioned that when the court handed down Casey in 1992, among the things that Scalia said in his stinging dissent was that this is going to promote litigation because nobody knows what undue burden is, and the courts are going to be clogged up with battles about it. But as I take a look, particularly a comparative look, back at the Brown versus Board of Education and the litigation and legislative activity it subsequently engendered, I think maybe we should ask the question, why is that such a bad thing? Why is it such a bad thing if you enunciate a standard that invites litigation and invites back and forth between the courts and the legislatures, both state legislatures and congressional legislatures, as they try to hammer out a solution to this problem where it's not the case that one is right and one is wrong, but both are right. You have two values that are legitimately affirmed in the Constitution, but can't simultaneously be very easily accommodated. Why is it so bad to have citizens work their way through fighting that out through the courts and the legislature rather than reaching for their guns and fighting it out in the streets? I'll stop there and you can all tell me why I'm wrong. Yes, ma'am. You have to yell because I'm a little bit deaf.
I thought it was very interesting. I hadn't heard about, I hadn't heard about Ginsburg arguing that maybe a better route would have been taking matters of course tonight. Very interested in contraception and right. And I've had discussions with people that really focus on how these are necessary for women's participation in society. I feel like at least the public message, the public discourse is about privacy, that isn't about equality, about brought out more. So to me, I think that holds a lot more weight, I think, than.
Well, I think that's an excellent question. And one thing I didn't say about what was problematic about the right to privacy, in addition to its lacking any obvious foundation in the Constitution, was it was really problematic for the women's movement at the time. It was problematic for the women's movement at the time because in most other areas, they were fighting against the notion of privacy. If you look at this was the era in which the women's movement was trying to get rid of the conclusive presumption against marital rape. There had been a conclusive presumption going back to the common law view that the wife was the chattel of the husband and the suspension of her legal identity during marriage, sort of old idea, an Englishman's home is his castle, and who is the Lord to intervene? So they were trying to break down the notion of privacy there. They were trying to get rid of interspousal tort immunity on similar grounds. And they were being very successful. In fact, we've gone from a world in the 1950s in which there was no crime of spousal rape in almost any jurisdiction in the U.S. to it's now a felony, I think, in 3/4 of the states and the federal system. Interspousal tort immunity is gone. So they were fighting against privacy in those areas, and reaching for it in the abortion area made things inherently problematic, I think, for the women's movement, never mind anything else. And I think that was part of Ginsburg's point in her 1991 speech, that looking for a law for regulating reproductive freedom that was based on the idea of women's equality would have made a lot more sense. So I think that is right. I think had the court not in 1992 gone the stare decisis route, probably we would still be hearing a lot more about it now. But at least at the present makeup of the court, they've made it clear they're not going to visit the question of what the underlying basis for the right is. It has other important implications for things like abortion funding as well that I'll just mention. Yeah.
But you're not prohibited students from asking 34 or 5 questions, but there are other people. One more quick question for you. One more.
Yeah. Talk a bit louder. Well, in some circumstances, it will indeed involve. It'll, you know. I mean, for instance, in the Casey decision itself, they did a bit of this weighing, if you like, in that they said, well, to require a wife to tell her husband before having an abortion places an undue burden on the wife, because some men are physically violent and threatening and so on. On the other hand, to require a teen to tell a parent does not place an undue burden on the teen, provided there was a so-called judicial bypass. If she was too afraid of her parents, she could go to a court and get permission that way. Now, some people have said, well, this is so arbitrary. Why, what is the balancing being done here? And I think there's some merit to that kind of criticism, but I think that what's to be said in its favor is it is a kind of safety valve in a sense of it pushes it back to legislatures to try and find the best ways to vindicate one right that interfere with another right as little as possible. Sometimes it's not going to be, sometimes it's just not going to work because, it would be nice if all good things went together, but they often just don't. And so sometimes one side's going to win rather than another. But the idea is to try and blunt those conflicts as much as possible, push them back to other forums where people may come up with different ways of thinking about the problem that will make the clash that much, less sharp. But some of the time it's just not going to work. And so that is, just the case when you have a society in which there are multiple conflicting goods. Yes, sir. With respect to? Well, they rule out Well, that would be a very different world than the world even Justice Scalia or Justice Rehnquist has been advocating for the last 30 years. And I mean, I don't know of a single justice on the court who has ever taken seriously the notion that a fetus should be determined to be a person as a matter of constitutional law. If they did, abortion would be, you couldn't have the kind of statutes against abortion that you now have. Abortion would be prosecuted as murder, and women who had abortion would be prosecuted as accessories to murder. And that would be a very different world than, as I say, than the world that Scalia or Rehnquist is at. The only time there's, I think, one footnote in one opinion where Clarence Thomas sort of flirts with that idea and then backs away from it. So, but basically their view has been return this to the states. And as you say, the courts should not be in a position of deciding when life begins or what counts as a person. Whether Justice Roberts or Justice Alito is different on this question, I mean, we can only speculate. You could be right, but I don't see anything in anything that either of them has said that we could know. I mean, the only datum we have is that they didn't sign Scalia's concurrence. Yeah. Sure. I'm sure there are many people who do have that agenda. There's no question about it. The question is how likely are they to prevail among any of these people, any of these justices on the court. And I'm just saying, with the exception of, one quotation and one footnote by Clarence Thomas, I don't see it. But we don't know. Well, not to use the wrong metaphor here, but the jury really is out on Roberts and Alito. Yes, sir.
Better for the court to throw the issue back to the legislature because I could see the argument. But the issue of desegregation is just one hand you have the moral argument or policy, the counter argument. Well, where you fear racial conflict, that was a cover. That was essentially, like that's not a good moral argument. And so, why turn this back to the legislature? I can't think of a good moral argument.
Well, I think that the reason to turn it back to the legislature is that the courts lack the legitimacy to do it. That at the end of the day, federal judges are not elected, and they're not really accountable to anybody. And the more they behave as kind of super legislature, the more they arrogate authority to themselves, the more they undermine their own legitimacy. And so that doesn't mean they have no place in our constitutional scheme. They do. But the argument is that they have to act in a democracy-enhancing way. So I say they take, my own view is they should toss it back to the legislatures, but the legislature shouldn't have the last word. So I regard, for instance, the hearings before the 2003 Act that Congress held, they were clearly bogus hearings, and they were clearly not intended to get at the truth of the matter, but simply to reach a predetermined conclusion. I don't think the court should accept that, so they should toss it back again. and then Congress would have to grapple with it in a more serious way. So I don't see it as the legislature or the courts. I see it in this area as an ongoing dynamic process between the two as a way of managing and diffusing deeply conflictual issues as the society tries to hammer out some kind of compromise that it can live with. Pardon? I don't see why it's so bad. You know, as I say, you worry about litigation, but you ask yourself, compared to what? Compared to Civil War, litigation's not that bad.
30 years being denied a right to.
But the question is not, that's not the, I think that's not, wasn't the alternative. Because the alternative might have been Civil War. Or the refusal of the federal government to send in the troops. Yeah.
Other than, are there any other medical procedures other than those related to reproduction if there are constitutional political involvement?
Good question. Almost certainly, but I would think almost certainly. Yeah, euthanasia, the obvious one, euthanasia.
By the active.
Well, there's active and passive euthanasia.
I mean, we're holding the preventive is involved.
Pardon? Yeah. I didn't hear that, sorry. Artificial Food and Nutrition Act. I would think there's going to be more and more with respect to genetic engineering, stem cell research. I would think it's inevitable that there are going to be many. And many issues having to do with medical consent. Consent of minors to medical procedures, situations where Christian scientists don't want their children to have blood transfusions. Yeah.
Well, first of all, thank you. This is great, great overview, and I'm very sympathetic, actually, I find myself very sympathetic for arguments, but I wonder if being Roe and Brown is not more dramatic than the legitimacy argument, but that spending money, right? Spending lots of money. There's busing or building. And, I mean, that seems to be clearly within the legislative competency. Otherwise, we have the court deciding how to split up the pie. I just don't have the ability to make it larger. So that's just one pragmatic that. But then also, I would just like to hear you explore a bit more. You said that the courts need to be democracy. I would just like to hear you explore your theory of democracy a bit more. I mean, it seems like you're clearly gravitating towards democracy, but I just think it would be very interesting to hear you explore.
Well, I think at the end of the day, no government can do anything in a democracy unless it can build popular support for it. That's in the nature of democratic politics. So what we're talking about here is largely, at the margin. It's not whether the court can do it or the legislature can do it. The question is when the legislature doesn't do it, can this other institution somehow cajole, prod, encourage the legislature to rethink, to find some other way to tackle this issue, to build constituencies that can support it or not. Maybe not. Maybe there was no way the schools were going to be successfully desegregated well, you know, we got more desegregation in the southern schools than we did in the northern schools with the budget. Mm-hmm.
Clearly recognize that there's no, you're not going to have overwhelming population. Of course, there's going to be cost on.
But I think it's in the nature, you know, the framers were thinking more about a republic than a democracy. I'm more of a Democrat than a small d Democrat than a small r Republican. And I think we live in a democratic culture such that unless you can build a popular constituency for what it is, the rights that you want to vindicate, they're not in the end going to be vindicated. I think, you know, I think that the power of courts in democratic systems is vastly overestimated by lawyers. So, if you look at the political science literature, for example, going all the way back to Bob Dahl's critique Practice of Democratic Theory and subsequent work, you know, he asked the question, if you look at the protection of rights measured in the standard ways that they get measured by rights organizations and so on, and ask the question, do democracies that have judicial review protect rights better than democracies that don't have judicial review? And the truth is, if you look across the whole swath of cases, it doesn't seem to make much difference. If you look at the whole of American history, you know, not just the Warren Court, it doesn't seem to make much difference. If you look at countries like Canada, Israel, and New Zealand that have gone from not having judicial review to having judicial review, it doesn't seem to make much difference. So, if courts make a difference, it's probably at the margin. It's not, you know, this notion that they can step in imperialistically, that's some new reality, and people are going to accept it. It's not going to happen. I mean, Blackmun galvanized the pro-life movement. That's what he did. I know there's at least one person in the room who doesn't agree with that, but that's my view.
I would argue that. I mean, everything has to be democracy. Going back to the old system is actually what is democratic? Rather than declaring that judges are imperialistic, they argue that they operate within their sphere of authority, granted democratic, that we the people, the word that was not the citizens, have conceded to a series of self-dictation. And there's nothing more legitimate and more popular than the Constitution. There are popular judges. Right. But the argument is that in effect, another way of looking at this is that the public understands that the constitutional authority requires some set of disabling propositions to carve out a sphere. Classic interpreters in the 19th century, albeit not terribly democratic, I suppose, wanted to argue that when it was required was destroying the theme of that certain things in motion.
Well, I think that's right, but I think judges are acutely aware most of the time that their legitimacy depends on their not exceeding their role. And when they do, it's not good for the judiciary, among other things. You know, if you have a case like Bush versus Gore, where they clearly did exceed their role, if you had cases like that every other year, the judiciary would destroy itself. You can get away with one of those every 100 years, but for the most part, I think the instinct that most judges have is that they'd better be careful because they don't have their own, or at least they don't have their own. You know, the only authority they have is the reason for doing what they're doing. They don't want to saw off the branch they're sitting on, or they would be unwise to do it. And you know, I think the Roe versus Wade was not a decision that enhanced the legitimacy of the court. Yes, sir.
I happen to be the Golden State Chair of Republicans for Choice. But if I've been asked, I'm going to ask you, in the case of the crisis of mother or the thief, I know Rome says say the thief. I'd like to say in the case of what? Sir? Except your Rome, this is the Vatican, you know, the whole America White Coast. Rome says they say only the thief. Others don't like that idea. And I find people on both sides. I just wonder how you decide that. Or the mother.
Well,
I'm not trying to be controversial, but the host is a man, and we're working from an issue of male dominance and other things, and women's rights. You can laugh if you want, but it's true. Laugh or not so right, but you have a boy who is recognized as not subservient, whatever or whatever. And so after that point. But my question was,
That's what Rome says.
well, that's okay. Not in Rome. What I'm thinking
when in
is,
Rome, do as the Texans do.
I remember that going on. My worry is how do we balance judges have an extensive bit of education in order to become a judge. And I'm not trying to belittle legislation, but not all legislatures have that same level of education. So here we are matching what we want our state to decide. And so I'm trying to figure out how, when the board of lieutenant campus and they're determining debating high school and schools, that comes from, I think, an education stance of they're going to work it out, they're going to how popular military citizens got to be the tax. So I'm thinking the checks and balances. I want to see a check and balance. I don't want to.
Well, you know, on the merits, I'm inclined to sympathize with what you're saying, but democracy is not, you know, Plato's governed by philosopher kings. It doesn't guarantee us that the better educated view will prevail necessarily. You know, you could say, well, if you know, there's this rather amusing story when I think it was Nixon nominated Judge Carswell for the Supreme Court, and in the comments somebody pointed out that he wasn't perfect knife in the drawer, and somebody was heard to comment, well, you know, at least half the American people are mediocre. Why shouldn't they have a representative? Democracy doesn't guarantee that are going to prevail. Now, I think that if you want to look, as I said, I think this issue now that Congress entered the fray and did hold these hearings is a really hard question because they did. And you could say, well, if they were bogus hearing, the voters should, you know, should either care about it and throw them out, or they don't care about it, then the people deserve the government that they get. And I think that in this case, goes too far because Congress noticed it, in the hearings that they held, they did not challenge or grapple with the idea that if a more safe procedure is available, a woman should not have to undergo a less safe procedure. Indeed, they implicitly accepted it because they tackled the question, is it a less safe procedure? And if they produce the congressional record that is replete with factual errors and demonstrably so, it goes back to the trial court. The reviewing courts are not supposed to second-guess factual questions. It's the trial court. And then there's testimony about the factual questions. Well, one piece of testimony is these congressional hearings, but there's other testimony as well. American College of Obstetricians can testify, physicians can testify, people who perform different procedures can testify, and then the findings of fact, either a jury or a judge, if it's a bench trial, who carry the day. It's a matter of fact. It's a forum for settling questions of fact. You could just say, well, so Congress made all these, manifestly inaccurate statements. It's not surprising the trial court wasn't persuaded. Message to Congress: do better next time. So that is one way of looking at it. But I think it's in a way, what Congress did in that is relatively easy to criticize. You could imagine them having done things that would have been harder to criticize. Finding, an argument for why this isn't such a burden on the woman. And it does seem to me one could actually challenge the logic that there might be certain kinds of medical but are so obnoxious, or so objectionable to some people that you would say that the relatively small safety is outweighed by the obnoxiousness. And that would, I think, if Congress would be actually quite hard, it would be harder than what they actually do. I think it's partial birth is very hard for those kinds of reasons. But I think it's just fine for the court and the legislature to go back and forth about this. Given how difficult objectively difficult it is when you have these kind of conflicting goods, I see an alternative. I mean, it's a bit like your question. The truth is, the answer to your question, it's just a horribly tragic choice. It's not like there's a right answer. So it's a question of, managing the society when you have these conflicting things. Yeah.
I think I heard you say fine person, the whole person is right.
As a matter of constitutional law. Yeah.
Yeah. That's good news. But I think that would be a violation. And, let me get to my question. It's about a bill that was just passed our state legislature yesterday that has to do with not allowing abortion for reasons of gender and requiring the doctors to cure all kinds of information like she wants the abortion. Doesn't such a law violate both privacy, constitutional privacy, and also the separation of church and state issues? What about the issue of mental health? Of the woman's health being a determining factor?
Well, I'm not sure about the separation of church and state in this matter. On the state legislatures all over the country are enacting all kinds of restrictions on abortion that are then tested in the courts, and the question will be, does it impose an undue burden on women, and people are going to have to does it as to why it doesn't from both sides, and then somebody's going to have to adjudicate that. Those sound like very intrusive. So I suspect that I suspect that but that's going to be, there will be ongoing skirmishing at that time. It's just inevitable. And ultimately, in a democracy, elections have consequences, and get more or less conservative judges. I don't have the view that the judges on one side of this question are more political than the judges on the other side of this question. But if we get judges who start to be persuaded by these arguments, these rights will be further eroded. And so, it's a judiciary, just like the politicians, ultimately reflect the value of the population. It's just with a bigger lag. So there's not a bright line you can draw that's going to give you type of answer to that question. I would be surprised if that statute.
There's a young man over there that I've had a long time.
Your opinion, or the most likely replacement?
Who are the most likely replacements for Stevens and Ginsburg? Wow. Well, from what we've been hearing lately, not Harold Coe. He's the dean of our law school. Who I have no idea. I don't even know if President Obama has it. And it's not obvious when they're going to go. One might think that they'll go before the end of his term, but you never know. Stevens says he likes his job, and he's got no plans to go anywhere.
You talk about Stevens and Ginsburg, but there's seven others.
Yeah.
And there's no guarantee.
Yeah, and Clarence Thomas says he hates his job, and it's much too much work. So, who knows?
It's getting a bit late. I'm sure our speaker is tired. I'd like to thank him very much for all of this.
Well, thank you for coming.